In this presentation, we consider the Western Sahara case and in particular the International Court of Justice's advisory opinion on such. Let's first consider the facts and contextual background. At its most basic, the case of Western Sahara was a territorial dispute. The Western Sahara itself is a phosphate-rich desert located in the Atlantic coastal area of northwest Africa. It is surrounded by the Atlantic Ocean, Morocco, Algeria, and Mauritania. In 1884, Spain claimed a protectorate over the Western Sahara, and the land was therefore under Spanish control for quite some time. Since then, resistance had been felt from the land's indigenous population, the Sahrawi people. Here we can see an underlying theme of the ICJ's advisory opinion, that the Sahrawi people have long been fighting to have their territory recognized as its own independent state capable of legal personality. In 1960 respectively, both Morocco and Mauritania made irredentist claims over the Western Sahara. Their main contentions will be considered later. It suffices to say at this stage that tensions over the territory grew after the UN General Assembly passed a Resolution 1514, which was a decolonization policy promulgating the right of non-self-governing territories to self-determination and urges that the immediate steps be taken to achieve independence for these people. To facilitate this decolonization process, the General Assembly urged Spain to hold a referendum on self-determination for the Western Sahara people. It is important to note here that recognition of self-determination is one element of a state's personality because it's a way of acknowledging a state's capacity. Indeed, independence in this form is essential to statehood. But unfortunately, the referendum of self-determination was never implemented. Instead, because both Morocco and Mauritania maintained their claims, on 13 December 1974, the General Assembly requested that the territorial dispute be considered by the International Court of Justice. The court was asked for its opinion on these two particular questions, which will be discussed shortly. Despite Spain objecting to the proceedings, the court was satisfied that it had the discretionary power to render an advisory opinion on the legal questions posed by the General Assembly and found no compelling reasons for refusing to give a reply to those questions. So, in summary, and to put simply, we have a territory and their indigenous population struggling for decolonization in order to be recognized as an independent entity, and in the meantime, two states are making claims for the territory, refusing to recognize the self-determination of the indigenous inhabitants of the land. The ICJ was then called upon to provide a non-binding advisory opinion on this controversy, which they issued on the 16th of October 1975. The legal issues and the arguments of the parties before the court will now be discussed.
In the view of the court, Spain took colonial control over the land in 1884, although it had shown evidence of alleged earlier sovereignty in the 15th and 16th centuries. This was found to only be remote antecedents of Spanish presence on the West African coast. The lack of continuity between these two periods allowed the court to neglect any Spanish ruling previous to 1884. Therefore, this raised two significant legal issues. The first legal issue posed to the court asked whether Western Sahara, Rio de Oro and Saquia el Hamra, at the time of colonization by Spain, was a territory belonging to no one. The concept of a territory belonging to no one refers to the presumption of terra nullius. The question was not asked based on a territorial dispute, but was only concerned with identifying the period of the historical context. In this context, Spain's claim of terra nullius at the time of colonization assumes that Western Sahara was a territory open to legal occupation, leading to their acquisition of sovereignty. The court found that at the time of occupation, the territories were indeed inhabited by Sahrawi people. These were nomadic tribes of people that were politically organized under the representation of chiefs. This meant that Spain had acquired sovereignty by cession or succession or through agreements with local political rulers.
The second legal issue considers the question of what were the legal ties between this territory and the Kingdom of Morocco and the Mauritanian entity. In order to break down the legal question, we must first consider the context, and this can be found in the General Assembly resolution, where representatives of Morocco and Mauritania have acknowledged their interest in the future of the territory. During the discussion of this item, a legal controversy arose over the status of Western Sahara at the time of its colonization by Spain. As such, the General Assembly requested an advisory opinion on the important legal aspects of that problem. That legal issue or controversy concerned pretensions put forward on one hand by Morocco that the territory was then a part of the Sharifian state, and on the other by Mauritania that the territory then formed part of the Belad Shingiri or Mauritanian entity. This is how the question of legal ties between the territory and parties arose, but what exactly are legal ties? The term of legal ties is unlike the first question of terra nullius and doesn't have a precise meaning. As such, the scope of the question really depends on the meaning to be attached to the expression. In this case, the court made it clear that the legal ties between Western Sahara and the Kingdom of Morocco and Mauritanian entity must be understood as referring to such legal ties as may affect the policy to be followed in the decolonization of Western Sahara. In addition, with reference to that policy, the scope of the question was not to be restricted or limited to ties established directly with the territory, but would also need to consider and reference the people who may be found in it. As such, the legal issue ultimately extends to the question of whether Morocco or Mauritania has a link of territorial sovereignty or recognition by other states of the sovereignty over the territory. The arguments made by each party for those legal ties will now be discussed.
As mentioned, the court did not find it necessary to pronounce upon Morocco's view that the territory was not terra nullius at the time of Spanish colonisation, nor its correctness. Accordingly, in answer to the second question, Morocco's claims to legal ties were a claim to ties of sovereignty on the grounds of an alleged immemorial possession to Western Sahara at the time of Spanish colonisation. This possession was asserted to be grounded upon a public display of sovereignty that was uninterrupted and uncontested for centuries. Morocco had also requested the court to consider the Sharifian state's special structure, given it was founded upon common religious beliefs and the allegiance of tribes, as opposed to notions of territory. Morocco further indicated that the geographical contiguity of Western Sahara to Morocco and historical material was satisfactory in establishing claims to title based on a continued display of authority, with regard to the same application of these principles in the PCIJ Eastern Greenland case. In evidencing its display of sovereignty in Western Sahara, Morocco had invoked alleged acts of internal display of authority, indicated principally by an allegiance of Saharan Cades to the Sultan, as well as certain international acts so as to constitute recognition by other states of the alleged sovereignty over parts of or the whole territory. Such displays further included the confederation of technotribes and military decisions said to amount to acts of resistance to foreign penetration of the territory. Such claims deny Western Sahara the ability to be recognised as a state and potential international legal personality. To an extent, Morocco's notions manifest that legal personality is given here due to international actors being recognised by other states. Accordingly, the international acts alluded to in Morocco's assertions, said to have constituted international recognition of sovereignty, were reliant upon a series of Moroccan treaties, including one with Spain, a treaty with Great Britain, diplomatic correspondence claiming to indicate Spanish recognition of Moroccan sovereignty, and Franco-German letters exhibiting understanding of Moroccan territory.